right. We are talking today with Ambika Sapra she is the co-founder and partner at Sapra and Navarra. How are you doing today?
Good. How are you, Lauren?
Oh, I am wonderful. Thank you so much for speaking with us.
Oh, not a problem. My pleasure.
Excellent. So why don't you go ahead and kick this off with telling us, how did you end up specializing in franchise law and what drew you to the field?
Well, it was one restaurant and one case. That's how it started. And I still remember the name of our first case. The employer was hurting because their X mod was going up, their premiums were going up, and they wanted something different. And we used a litigation strategy called breaking the habit and got some really good results for them. And it took off from there. And I don't specifically specialize in franchise law. I do workers' compensation. I'm a specialist in workers' compensation defense, and I represent the franchisees. So that's how it started. One case and one restaurant.
I see. That's excellent. So what do you think is the biggest legal hurdle facing the franchising industry in 2021 and going into 2022?
Several of them actually, some old, some new. The biggest one is a continuous trauma claim. It's always been there and it keeps rearing its ugly head. Just briefly, a continuous trauma claim is a repetitive injury over a period of time rather than a slip and fall, rather than a specific instance. And continuous trauma claims, the unique thing about them is that the franchisees are blindsided. They don't know it's coming because there's no reporting of an injury, there is no treatment, there is no modification of work. So they are flabbergasted when they get a claim for a continuous trauma claim. And another reason why they're so surprised is because continuous trauma claims, when the franchisees get an application for a claim for a continuous trauma claim, they think that the person has to work there for several years. Only then they can get a repetitive injury, right? You work for several years and you get injured. For example, a typist who works for years and then gets carpal tunnel syndrome. But here, I'm going to burst their bubble. The courts have held that even 4 hours of employment can suffice for a continuous trauma claim. So it's a really big shock for them, the employers, our franchisees. And continuous trauma claims are very difficult to defend in California. Almost 1 in 5 indemnity claims in California are continuous trauma claims. They cost a lot of money, and the employers better have a good strategy, a sharp litigation strategy to defend them. So that's the first challenge I can think of in 21, 22. The second would be the rise in minimum wages. The minimum wages are increasing, which directly impacts the total temporary disability and the permanent disability, which comes from the employer's pocket, and again has financial consequences for the employer. So that's number 2. Number 3 challenge would be a shortage of labor, which everybody is talking about these days. And the shortage of labor means that our employers, our franchisees, may hire people who are not skilled enough. And that means the injuries may be higher and the frequency of those injuries go up, thereby impacting their bottom line again. It's all about money in workers' compensation. So every action has a consequence, and every consequence equates to a dollar value. So that's what happens when if they're hiring unskilled labor, then the frequency may go up. Another challenge that I can think of is, of course, COVID. COVID is the new thing. COVID claims are coming up. COVID is, just to expand upon it for our listeners, for our readers, for our viewers, COVID is simply a diagnosis, right? So how does an injured worker claim COVID? A COVID claim is claimed by claiming multiple specialties. For example, there is hair loss, so there will be dermatology, there will be pulmonology, immunology, cardiology. So the applicant or the injured worker is called the applicant in California. The injured worker will claim 3, 4, 5 different medical specialties. Now, imagine, Lauren, that the injured worker is treating in all these specialties, right? And the employer is paying for the medical bills of all these specialties, and how costly and how expensive it can get for the employer. To top it all, the law has enacted certain presumptions in favor of the injured worker, and they are very difficult to rebut these presumptions. And so again, a very, very good litigation strategy is needed, and they need to figure out, what they are doing to defend the claims. So that's a new challenge that 21, 22 will bring for our employers. The next thing that I can think of is a shortage of claims examiners. There are labor studies that have come out that there's a shortage of skilled claims examiners because I think everybody's reevaluating their lives these days and trying to go into professions that they like or they enjoy more. So there's a shortage of claims examiners, which means that the claims examiners who handle the claims of the franchisees may not be skilled enough to handle those claims because it's such a complicated legal jargon, the workers' compensation in California. And if you're not skilled enough, that has a direct consequence on your finances. And that's why I said earlier, for every action, there is a consequence which relates directly to a dollar value. So these are about, I think, 3, 4, 5 challenges that I can think of right now, which will impact the bottom line of the employers in 21, 22.
That's excellent. Those are some really good points, especially the labor shortages. We're hearing that everywhere. Absolutely.
Right.
So what is the most common mistake that you see franchise brands making from a legal perspective?
Chasing after unicorns. Our employers think that there is some magical fairy dust or some magical cure that will either make their cases cost a lot more or the frequency will go down. And there isn't. There is none of that. And I don't blame the employers because they're desperate. Workers' compensation is a huge overhead for the employers. And in California is the most expensive state of workers' compensation. So they're at a loss. They don't know what to do. So what they go for is two basic things. First, they go after legislative changes. And the last major legislative reform was in 2004. And it absolutely did no favors for the employer. So when that doesn't work, then the employer thinks, okay, what else can I do to make a difference in my cases? So they play musical chairs, which means that this industry, it's rife with changing of vendors. Every few years, there's a change of third-party administrators, change of brokers, change of defense attorneys, change of carriers, because the employer is looking for a solution. But the problem with playing musical chairs is when you're using traditional strategies, you get traditional results. It's as simple as that. And traditional strategies in California and the traditional result is $85,000, an average of $85,000 per case, and it lasts for 3 years, a litigated case. So think about that, an average of $85,000 and 3 years. So how expensive it is for the employers. So what I tell my employees, because they are so good and they are so nimble, they are so swift when adapting to changes in their business. For example, when the health food thing came, they were very quick to adopt healthy options into their menus. When COVID came, they came up with the delivery, the contactless payment, etc. So they're really good when making new changes in their business, and they should apply that same formula, that same strategy to their workers' compensation cases as well. Don't go for strategies which are 100 years old, which will yield traditional results. And like I said, $85,000, 3 years. Think about other things. I mean, there are so many things being done right now. For example, technology, artificial intelligence. Now, given law is not at the forefront of technological and innovative changes, but things are being done. So explore those, talk to your claims professionals for something which will make a difference in the cases, not just the same old thing, which makes no difference, absolutely no difference. Their premiums keep going up, the XMOD keeps going up. And this is really an insight I'm going to give our employers. Don't go after fairness. Don't go after truth. Don't go after, I will handle this case on a case-by-case basis. Let's see what happens. Because American justice system is not about truth or fairness. It's an adversarial system. That's why there is a V in between the parties. John Smith v. Hardy. There's a V in between the parties. It's not an inquisitorial system like in Europe or in the Middle East, where even the judge will ask questions. They will go after a truth-seeking mission, not in the American justice system. It's a battle, it's a war, and you better have a warfare strategy if you want to win the battle. So that would be my advice to our franchisees.
That's excellent advice. And you can already tell that you love what you do, but what do you love? You do, yes. What do you love specifically about working with franchises?
Specifically, I think they are, they are human beings. They're mom and pop individuals who started businesses. They're part of a huge corporate structure, but it doesn't feel that way. They work there themselves. Every dollar counts, every penny counts. Their family members work there. And when I have a good relationship, when they defer to my judgment, uh, when they agree with my judgment, then I see, and I've applied this over and over and over again in my cases, it's a very healthy, very efficient, very magical relationship, which again directly equates to savings for them. Because that's why they come to me, right? They're not coming to me just because they like me. I mean, I'm sure they like me too. I'm a very likable person, but they want results. And the reason they get results is they defer to my judgment, and they're open and willing to try a strategy which brings them the results. So that's what I like about working with them.
Fantastic. All right. So I have one last question for you. What is one thing that you think every prospective franchisee should know before joining a franchise brand?
You will get sued.
Yeah.
Don't be surprised. You are going to get sued. Don't take it personally. Just like you sell food in bulk, you are going to get sued in bulk. That's the bottom line. And be prepared for that. Like I said, it's a battle, it's a warfare. Alexander the Great didn't win all the way from Macedonia to India by not having a warfare strategy. He had a great warfare strategy, and he just plundered through all these countries and reached India. So you have to have a good warfare strategy. And like I said, American legal system is not about truth. It's not about fairness. It's an adversarial system. It's not an inquisitorial system. So don't take it personally, but be prepared. Otherwise, these costs are going to hit you tremendously. Workers' compensation is a huge, like I said, a huge overhead for our franchisees. Their profit margins are very low when they sell, their food. So they have to be extra careful. And another thing is, this is not like a factory where you can get 2 or 3 cases a year. These cases, again, I'm going to repeat it because it's such an important point. These cases come in bulk, and you better have a strategy that applies universally, uniformly to all these cases if you want to see the results. Because you might get a good result on one case. Okay, fine. I'm very excited, and all of us get excited. I got a great result on one case, but 10 of your cases are bleeding you dry. So that doesn't make good business sense. So think like a businessman, and that's how you handle workers' compensation cases in California.
Fantastic. Thank you so much. That
Thank
was
you,
so nice
Lauren.
talking
Thank
with you.
you. It was great. Thank you.
Thank you. All right.
Bye.